Okay, good morning. Welcome to an oral argument session of the Fifth District Court of Appeal. We have one case on the docket here at 11. It's Universal Property and Casualty Insurance Company versus Teresa and Richard Gumpel. I am Rand Wallace. I'll be presiding over the case this morning. I have joining me on the panel are Judge Jim Edwards and Judge John McIver. And Mr. Noel, I would assume that you would like 5 minutes of rebuttal unless you advise me differently. And I would just ask that we silence any devices that may unexpectedly make a noise. And probably the safest thing to do is just mute your microphone when you're not presenting to the court. And other than that, Mr. Noel, you may proceed.
Thank you, Your Honor. May it please the court. Your Honors, good morning. My name is David Noel, and I represent the appellant Universal, and I would please like to reserve the 5 minutes for rebuttal.
You got it.
So, Your Honors, this appeal is really based on contract interpretation and statutory interpretation, which are questions of law. We had two motions for directed verdict that are being appealed and that are the subject of this oral argument today. And those both stem from the contract language in our loss settlement provision, which tracks Florida Statute 627.7011(3)A. And the language in that provision, what it says is that it's a replacement cost policy, but it's subject to the following language, which says we will pay the cost to repair or replace, but not more than the least of the following three amounts. And the third amount is the necessary amount actually spent to make those repairs or replacement. Later on in that same provision, it says that we need to initially pay at least the actual cash value, and then the remaining amounts, which is the replacement cost, is paid as work is performed and expenses are incurred. So the critical language there, work is performed, and also the prior language about necessary amount actually spent. In this case, it was undisputed at trial that the plaintiffs had not actually performed the work. There was testimony they entered into a contract, but the work was not performed. It was a roof replacement case. So that work was not performed. Now, the trial court and this court was not able to rewrite the contract or the statute saying without the work being performed, you can't get replacement costs. You can only get actual cash value.
Counsel, let me interrupt you just for a second. The policy does not define actual or replacement cost, does it?
No, Your Honor, those are defined as legal terms of art in the case law. And there's extensive case law, especially on the definition of actual cash value. And we do cite that in the briefs. The definition of actual cash value from the case law essentially says that it has to be the property that was actually damaged. Doesn't include the undamaged property.
Right. So, but under your definition, then, if you did have a wind or hail damage that ruined 500 shingles across the roof, then your company would only have to pay up front for 500 new shingles, right?
Your Honor, it would be the 500 shingles damaged by wind minus depreciation. That would be the actual cash value.
Okay, and at that point, without looking at what the normal replacement would be, that'd be it. However much 500 shingles cost, that's what you say you would owe up front, correct?
Correct. And then at that point, the insured would have the option to make the repairs if they chose to. The thing about an actual cash value payment is you're not required to use that for repairs. You could use that money for anything. It's just the purpose is just to make you whole for the loss you suffered. So if you wanted to buy a car, a boat, pay down the mortgage, nothing would stop an insured from doing that. And we actually know this from the public policy and the legislative history that's behind this statute. It's actually cited in the plaintiff's answer brief, an important portion of it. That's on page 45 of the answer brief. And what that legislative history says, and it's the same legislative history we cite and quote in the initial brief, just a different portion of it. But it says that following multiple hurricanes of 2004 and 2005, regulators received complaints from policyholders who were given the ACV but could not afford to fund the balance necessary to make the repairs. In 2005, the legislature addressed this problem, and they said in the statute the insurer must pay the full replacement cost. And again, that's a statute I referenced, the 627.7011, but that was only in effect for 6 years, Your Honors. In 2011, the legislature took a second look and said, you know what? This system is not working. We're concerned about inflated claims, and we're concerned about insureds not making the repairs. They're not required to make any repairs, and if you advance them all the money up front, you have no control over if those repairs are made.
And
So in 20
what evidence did y'all put on at trial about what the actual cost was, what the actual damages were? Did you have your adjuster or inspector testify?
The field adjuster did testify at trial, Your Honor, but it is important to note that it would be the plaintiff's burden of proof to prove damages as an element of their cause of action for breach of contract.
And
So
didn't they
to
offer
prove-
Mr. James, who testified that I mean, I think he gave a couple of different dates, which is another interesting thing here. There seemed to be one lost date pled in the complaint, but then two lost dates talked about at trial, but that's another issue. But didn't James talk about actual cash value as being the replacement cost value less depreciation?
That's correct, Your Honor, but there's a problem with Mr. James' testimony because again, actual cash value is a legal term of art that's defined in the case law. And Mr. James admitted that there was only sporadic damage to the roof and that his estimate did indeed include undamaged areas. And it included extensive costs that would only actually be incurred if the roof was replaced by the insured. So by giving that testimony, even though Mr. James said, yeah, this is an ACV number, he provided testimony directly to the contrary under the legal definition of actual cash value. So that was really not evidence that met the burden of proof that the plaintiff had to prove that actual cash value. You can't just have an expert come in and say this is actual cash value if he then contradicts himself as to the legal definition of actual cash value. And that's really the problem here. The plaintiff also presented the testimony of an engineer, James Funderburk, who testified only 61% of the roof was damaged. So it was undisputed at trial that the amount of money plaintiffs were claiming, their alleged actual cash value number, it included undamaged property. Most of it was undamaged property, or a lot of that roof was undamaged property, and that doesn't fall within the definition of actual cash value. And the jury wasn't given any tools to be able to subtract that out. There was nothing in the testimony of Mr. James or Mr. Funderburk that would have allowed the jury to figure out how to get to a real ACV number without guessing or speculating. And that can't support a verdict in the plaintiff's favor. Jury can't guess, can't speculate. And it really wasn't even disputed at trial by the plaintiff's trial counsel that replacement cost value wasn't triggered yet. We did point that out in the briefs. There were a couple of admissions by plaintiff's trial counsel. The first one was on page 535 of the trial transcript in the supplemental record. And the judge had asked plaintiff's trial counsel, if the jury gives you your best day, what happens? And then that trial counsel said defendant would immediately owe the actual cash value less the policy deductible. That's exactly the argument here. It was not a replacement cost value case because the repairs weren't made. A few pages later in the transcript, page 538, the same plaintiff's trial counsel said, what they would need to do, referring to plaintiffs, is show that they have expended the money and then they would be entitled to the replacement cost. So it really wasn't controversial at trial that the replacement costs not being triggered were an actual cash value case. So the replacement cost value motion for directed verdict should have been granted. We should not have been subject to a verdict on replacement cost value. And that number actually made it into the final judgment. The verdict form had both replacement cost value and actual cash value, the judgments for the replacement cost value. So certainly that's something that it should have been directed verdict and knocked out at that point. Same thing for the actual cash value, simply because, as I mentioned, Mr. James and Mr. Funderburk did not put forth testimony or evidence that would allow the jury to calculate the actual cash value. And the case law we cite, for example, regarding how to define actual cash value, we do cite the Vasquez case. And that case, just a short quote from it, is consistent with this plain meaning. The trial court determined that the insured loss is the property that was actually damaged. So what that stems from is the insuring agreement in the insurance contract, which says we insure for direct physical loss. So it's a policy meant to address direct physical loss. And when you're talking about actual cash value, that's what you're looking at. The remainder of the money, the undamaged property, the depreciation, all of that is held back as a decision by the Florida legislature that we want to encourage repairs and we don't want inflated estimates. Once the repairs are made, we have canceled checks, we have invoices, so we know exactly what the amount is, and we know the insured actually used that money the way the legislature wants to encourage them to use it. So at that point, they trigger the greater payment of the replacement cost value.
Council, let me ask you this about legislation. You guys rely on 627-70152 that a pre-suit notice was required in this case, correct?
Yes, Your Honor, that's our second point on appeal.
All right. Did y'all ever move to dismiss based on that statute
There was
prior to trial or during trial?
There was not a written motion to dismiss filed. The issue
Was there an oral motion to dismiss during trial?
not in those specific words, Your Honor. The way it was addressed at trial, and I want to give the quote.
Well, I know there was a stipulation about the plaintiff had admitted that they did not file a pre-suit notice of intent. They filed a notice of intent after suit was filed. But that's the extent of the stipulation. It was, here's when it was filed, here's the date of the suit filed and so forth. But in terms of moving to dismiss during trial or before trial, I didn't see that. Am I correct with that?
Your Honor, you're correct, but it's still important to note that this was brought up very early in the case in the form of an affirmative defense.
Well, I
So-
understand that, but you can raise all kind of things if you never bring it to the court's attention and ask for a ruling at the appropriate time. That's a problem because you could have an affirmative defense you put in there and that you later decide whether it applied or not. You don't want to pursue it. And here, the remedy for not giving the pre-suit notice, assuming it's actually required, is a dismissal without prejudice. So it doesn't make any sense to me that if the remedy is a dismissal without prejudice, that shouldn't be brought up before or during trial at the very latest. And y'all did not do that.
So, Judge, I would say in the context of the trial transcript, it was fairly placed before the trial judge.
Where?
That discussion started on page 484 of the transcript in the supplemental record. And that's where Universal's trial counsel is bringing it back to the judge's attention.
That's post-trial though, right?
No, this is in the trial transcript itself. It's at trial. Our counsel doesn't use the specific words motion to dismiss, but our counsel does start by saying we do have a pending defense relative to the notice of intent. And that's page 484 of the trial transcript in the supplemental record. That is day 2 of trial. And the judge mentions one page later, page 485, that it's something we certainly talked about prior to trial. So the trial judge is stating there on the record that this had come up before trial. Obviously, it was pled in the affirmative defense. So it's not something we sat on and waited for post-trial. It was before the trial court. And I think looking at that discussion and back and forth between our trial counsel and the trial judge, it really leads to the conclusion that the trial court was wanting to push the rulings until post-trial. And the trial court was like that with the directed verdicts too. I think the judge's words were, it's denied without prejudice. We'll deal with it after the verdict. So looking at that transcript as a whole.
That's a directed verdict. I'm going back to the motion to dismiss. I didn't see a written motion to dismiss, and I don't ever see that argued, that argument about you should dismiss because of this until post-trial. It's not in the transcript, is it? I mean, there may be some mention of it, but mentioning that we have a defense or that we want to talk about something, it's not, it's not ever made. That's my concern.
I would agree, Your Honor, that there's definitely no written motion to dismiss, and counsel did not use the specific words at trial motion to dismiss. But I think looking at the back and forth discussion, especially
in the directed verdict, did trial counsel say and we're entitled to a directed verdict because we got a stipulation that they didn't do a pre-suit notice.
That language is also not directly in the trial transcript, Your Honor. All it has is the back and forth discussion between counsel and the trial court referencing, we had talked about this prior to trial, that it had affected the jury instructions. But no, there's no specific words, Your Honor, motion to dismiss. There's no specific words, directed verdict on the notice of intent. Nothing that concrete until the post-trial motions. But the fact that it was pled and it was discussed at trial, the trial judge was aware of it even before trial by the judge's admission. It was placed squarely before the court. The statute is straightforward. It says you must dismiss. There's nothing in the statute that says there's a time period you must file the motion. And for those reasons, we would take the position it was preserved. Thank you.
Thank you, Mr. Kling.
May it please the court. My name is Aaron Kling and I represent the Gimpels. In closing, Universal's trial counsel told the jury, you get to make the decision as to whether you were shown that there was enough damage on that roof to warrant the whole roof replacement, or whether you were just told that. And that is the crux of the case that we're in here today. Florida law and the policy agree. The jury gets to determine disagreements as to the scope of the amount of the insured loss, not the insurer unilaterally. If we look at section F of the conditions section on page 1557 of the record, goes to 1558, it sets forth 3 options for resolving a dispute regarding the amount of the insured loss or the scope of the insured loss. And that is mediation, appraisal, or trial. It specifically says, if we fail to agree on the amount of loss, you or we may, 1, request appraisal. It goes on to say, if, however, we demanded mediation and either party rejects the mediation results, you are not required to submit to or participate in any appraisal of the loss as a precondition to an action against us for failure to pay the loss. Subsection J, also in the conditions section, requires Universal to adjust the loss with the insured, and says the loss will be payable upon the earliest of the following: 20 days after we receive your proof of loss and reach an agreement with you or settlement, or 60 days after you receive your proof of loss and there's an entry of a final judgment, or there's a filing of an appraisal award or a mediation settlement with us. In Curtis versus Tower Hill, the second DCA held that when an insured files an action on an insurance contract to determine their entitlement to the amount of damages, that loss settlement provision of the policy didn't render suit premature. Indeed, that provision expressly contemplated that there might be a final judgment, presumably stemming from a lawsuit, before the payment was due. Now, this is consistent with Universal's compensatory damages instruction and Judge Atkinson's reasoning in Brito and the court's reasoning in Weston, and then the 6th DCA's reasoning in Rodriguez, and also that in Teo out of the 3rd. In Teo, Brito, and Rodriguez, the courts held that section 627-7011-3 or paren 3 governs an insured's post-loss obligations in adjusting and settling claims covered by replacement cost policy, and does not operate as a limitation on the policyholder's remedies for a breach of contract action, or for a breach of an insurance contract. As Judge Atkinson explained in Brito, the legal proceedings necessitated by the insurer's alleged contract breaching denial of coverage are designed to adjudicate not only whether the contract has been breached, but also the precipitate damages incurred by the insureds by way of assessment of what position they would have been in had the breach not occurred. That includes not only the actual cash value of the payment, but also additional payments to account for the replacement cost that the insurer would have been obligated to pay upon making of the repairs had it not allegedly breached the contract by denying coverage. In an action...
Counsel, Brio was a denial of coverage case, right?
Yes, Your Honor. And that was a denial of coverage case, and then it was expanded in Weston. This case and I'll get to Weston later too, but this case is completely analogous to Weston. Same insurance company, same attorneys on both sides. Many of the experts one of the experts was the same. I think that the same result should be reached. But yeah, to answer your question directly, yes, Brito was a denied case. And they went on to say that in an action precipitated on a denial of coverage that allegedly breached the insurance contract, that the facts insurance contract makes replacement costs contingent upon the basis of the costs having already been incurred does not foreclose an adjudication of what those costs would be had the insurer complied with the policy. And that language is quoted by the 6th TCA and Rodriguez as well. And Judge Atkinson explained that litigation is often backward and forward looking. And the damages inquiry in a breach of contract action inherently includes what would have happened if they hadn't breached. As Universal's trial counsel described, compensatory damages is the amount of damages which will put plaintiffs in as good a position as it would have been if the defendant had not breached the contract, and which naturally resulted from the breach. And that's it. He makes that argument at the appendix at 657. And then a jury instruction was given regarding compensatory damages. That instruction stated compensatory damages is that amount of money which will put the plaintiffs in as good a position as it would have been had defendants not breached the contract, and which naturally results from the breach. And that was the Universal's 10th proposed substantive instruction. Accordingly, any error in damages based upon their instruction is invited error and can't be the basis of a reversal. As Judge Atkinson pointed out, it defies logic to limit such an inquiry to actual cash value when the contract governing the action entitles the insured to replacement costs without a deduction for depreciation. Now, interestingly, in this case, it's a little stronger than Weston for the insureds, because in this case, payment of the RCV was in fact triggered. Universal admitted, and there's testimony support from the corporate rep at page 323 of the appendix. Universal received an estimate for the full cost to replace the roof from AAA Roofing. Universal was aware that the insureds had at least one estimate and had requested a full roof replacement at the time when Universal determined its estimate. That's at page 324 of the corporate rep's testimony. Rather than saying, yes, we will pay for this contract for repair you've given us, they responded with the following. Regretfully, we are unable to make allowances for your claim. And that was at the record at page 1588. A reasonable jury could infer from that this was a denial of the roof replacement, and that a genuine issue of fact occurred regarding the extent of the loss. Mr. Goipel testified that he contracted for the roof replacement with AAA, and Universal's trial counsel reminded the jury, you heard Mr. Gimple take the stand. He testified that AAA is going to replace that roof. He's under contract with them. They are bound. And he says that at page 657. Pursuant to this court's analysis in State Farm versus James, that means the Gimples incurred the replacement costs that triggers payment under the policy for the RCV. At page 1557 of the record, it says we will initially pay at least the actual cash value of loss, less any applicable deductible. We will then pay any remaining amounts necessary to perform such repairs as work is performed and as expenses are incurred, subject to 2A and 2B above. As in this context is a conjunction meaning while or when, but it doesn't mean after. The defendant has breached the and then in the complaint, we filed a complaint that didn't seek actual cash value, that seeked replacement cost value. And it said that the defendant breached the policy by one, failing to acknowledge the entire covered loss and pay the full amount of benefits. And that matches the introduction jury instruction, which was given at 1691. The actual cash value definition suggested by the by Universal is more restrictive than the plain meaning and therefore can't be applied. There's also a preservation issue as to whether or not they made that exact argument. There was a motion in limine, but there's no order on that motion in limine. There's no transcript about what was argued at that motion in limine. We can't tell what happened there. But if we turn back to State Farm versus James, and Judge Edwards, you're correct. Actual cash value is not defined in the policy. And since UPCIC drafted the policy, the definition has to be construed against it. And if the language is susceptible to more than one reasonable interpretation, one providing coverage, any ambiguity should be construed in favor of coverage. In contrast to a replacement cost, the Supreme Court of Florida and the second DCA have both defined actual cash value to include things that aren't direct physical damage. For instance, it says, in contrast to a replacement cost policy, actual cash value is generally defined as fair market value or replacement cost minus normal depreciation, where depreciation is defined as decline in an asset's value because of use, wear, tear, or age. That was the interpretation of the ACV by the Supreme Court and the second DCA. Replacement cost, less depreciation, nothing more.
And that's what your expert James testified about, correct? Your roofing expert?
That is what he testified was the industry standard. There was no testimony against that. Your Honor asked whether or not anyone testified on behalf of the carrier as to whether it paid the actual cash value. No expert was called and that gave competent expert testimony to testify that this was the appropriate ACV or actual cash value of the loss. Therefore, they could not meet that burden to say that this was the ACV. So that their argument's completely unsupported by facts in the record. But if I go on to what in Trinidad and in Gulf, the second district court concluded that overhead and profit are included in the scope of actual cash value, where the insured is reasonably likely to need a general contractor for repairs. The second district court correctly determined, in essence, that overhead and profit are like all other costs of repairs, such as labor and materials that the insurer is likely to incur. The second district therefore held that a portion of overhead and profit, like a portion of all other costs, was included and could not be depreciated in an actual cash value policy. So therefore, the Florida Supreme Court had held any cost reasonably necessary to bring the property back to its pre-loss condition was recoverable as ACV. That is a reasonable interpretation, I believe. And if that's a reasonable interpretation, then the James case would indicate that you have to apply that interpretation, which affords broader coverage.
Let me interrupt you for a second on the
Yes, sir.
To change channels a little bit on the pre-suit notice that appellants claiming applied. We won't get into whether it did or not, but again, my question is, did they ever move to dismiss or move for directed verdict based on the lack of a pre-suit notice being provided?
No, Your Honor, and this court is tasked with ruling on the lower court's rulings, and no ruling was made. That's simply not preserved for appeal. And even
that I differ with you a little bit, because I believe Judge Falvey said, look, I hear what you're saying, but I'm bound by the Fifth District Court of Appeals decision, didn't she? I mean, she didn't say denied or granted, but she goes, look, I'm bound by the Fifth DCA's opinion. Didn't she say that, or am I misreading that?
I didn't catch that, Your Honor, but that may be in there. And if it is, yeah, they may have made that argument, but that's not the type. Well, first, saying somebody's bound for something could just be saying, this is what I projected that I might do. It's our job to force a ruling. It's the trial attorney's job to force a judge to make a ruling that can be appealed. It doesn't sound like any motion was made or a ruling was made.
Is that what the
It
statute
sounds
says?
like, I'm sorry, what?
Is that what the statute says? Statute says a court must dismiss without prejudice any claimant suit relating to a claim for which a notice of intent to initiate litigation was not given. So if the court is aware that there is a claim, a claimant suit, and we are aware that no notice is given, seems to me the statute provides a court must dismiss it. I understand how we normally operate all of the time, but it seems to me like we're reading in this requirement for a motion into a statute where it's not there. Tell me I'm wrong.
Well, first, Your Honor, I think in order to avail yourself of any statute, you have to bring it as affirmatively, and the court
Yeah,
is.
you have to make
is-
the court aware, sure, but if the court is aware that there is no notice, it seems to me the statute says dismiss it. Are you
Well-
saying that the statute could not be telling us to sua sponte dismiss a case?
It definitely doesn't say dismiss it sua sponte or make yourself the attorney for either party. However, in this particular case, this court's bound by its prior ruling that this doesn't apply to this.
It
The
doesn't.
67-70152 doesn't apply to this case.
Would the legislature be making us an attorney's party by saying you're aware that there's no notice? A notice is a condition precedent to filing suit. They didn't do it. Dismiss this case. It is a void claim. It is a void suit.
Potentially, maybe. Again, this court's bound by its prior ruling and the holding in Menendez.
I hear what you're saying there. I'm just asking you if that is an unfair reading of the statute.
I wouldn't agree with it, Your
What does
Honor,
the
but I think
statute
it's
say?
yeah, Your Honor. I don't agree. I don't agree that you can avail yourself of a protection without pleading it as an affirmative defense or raising it as a motion. That said, Your Honor, I don't think it affects your decision in this case. So
And again, you're saying you can't avail yourself of a protection. The legislature directly told us what to do. They didn't say do it on behalf of one party or on behalf of another party. They said do this. The legislature has an interest in both parties. Sure, they also have an interest in the entire state of Florida. And they may be saying as a matter of policy, they have made the decision that these suits will not move forward if there is no notice.
I mean, they could have said that specifically, and they could have said specifically that it applies to cases that were filed that were.
Did they
where
not
the
say that
policies were
specifically
issued.
when they said any claimant's suit?
No, Your Honor.
Any claimant suit, not the ones that have been moved for, but any claimant suit.
Well, I mean, it does say that, Your
All
Honor.
of
So,
them.
yeah,
All the
potentially.
suits.
Again, I don't think it affects this case. So if I may, I can move on to something that does. As I was saying, Universal's interpretation of actual cash value is forced and unnatural. A normal person on the street would never provide the strained interpretation that Mr. Knoll provided. It's not in the definition section of the policy. Actually, actual cash value is not in the perils insured against section of the policy either. It's 7 pages away, and that is in the condition section of the policy. Interestingly, Universal argues that the words direct physical damage, which are in the perils insured against section, modify the scope of coverage for actual cash value, but don't modify the scope of coverage for replacement cost value, despite the fact that both of those words are on the same page, 7 pages away. It defies logic that one statement 7 pages away can modify actual cash value, but not modify replacement cost value. Nothing that the insurer or Universal sent to the insured during the adjustment advised of that strict definition either. And because it's more restrictive than the plain meaning as defined by the Florida Supreme Court in the 2nd DCA, you cannot apply that. I think I discussed the fact that there was no support for the actual cash value determination made by Universal. I think there was an argument that this would somehow expand coverage. In Brito, Judge Atkinson covered that He pointed out that the coverage actually already exists. The insurance contract provides for replacement costs without a deduction for depreciation and obligates the insurer to pay initially at least the actual cash value of the insured loss less any deductible, and then any remaining amounts necessary to repair. And to the extent that an order of law settlement described in the policy requiring the work to be performed and expenses incurred before the insured's obligation to pay replacement costs arises could be characterized as a condition precedent. It's not a condition precedent to bringing a loss suit premised on a denial of coverage. A more analogous case to this one would be the Weston matter. In Weston, they addressed the directed verdicts brought by the insurer in this matter. And then I would add that the sixth supports this. It would seem that the sixth and this court in James would agree that one does not have to do the repairs in order to dispute the scope of coverage. Therefore, I would ask that your honors affirm the judgment of the lower court and remand.
Thank you, Mr. Kling. Mr. Noel.
Thank you, Your Honor. I do want to touch on some of the case law that was cited by Mr. Kling and the supplemental authorities that were also filed. So in terms of this court's case, State Farm versus James, that was dealing with a tear out provision that only said you had to incur something. So a contract was enough. The language we're talking about in this appeal says a lot more than incur. It says as work is performed, and it also says amount actually spent. So we're not talking about incurring, we're not talking about a contract. You got to spend the money, and that's consistent with the case law. The Trinidad case from the Florida Supreme Court, footnote number 1 of that case specifically says it was decided under the old version of 627.7011, specifically the 2008 version before it was modified in 2011 when the legislature realized repairs aren't getting made. And that footnote 1 ends with the words, "Our analysis in this case therefore applies only to the version of the statute in effect in 2008. So it's not relevant to our case here. Really, we're governed by the supremacy of text principle. The Florida legislature writes a statute, parties enter into a contract, and courts have to enforce the plain language, especially when the legislature is incorporating a significant shift in public policy. Even if there's a harsh outcome, the legislature looked at that and went from catering to policyholders to having to reverse course and change the statute based on their determinations. Now, this court's own case law in the Slayton case enforced a similar provision talking about we do not pay more than the least of the following 3 amounts, the third amount being the amount actually spent. And this court in Slayton said that's unambiguous language. It's not confusing. It's very straightforward. You have to spend the money. The Qureshi court, the 4th DCA, reached a similar conclusion. They said, we're not going to rewrite this contract. Otherwise, you're creating coverage by waiver or estoppel. There's no coverage in this policy for unperformed repairs. If you perform the repairs, then you get that replacement cost. Otherwise, it's actual cash value. We're not saying you don't get paid anything, but you're limited to the actual cash value. And the 1st DCA has also reached a similar conclusion in the Clark case, which we cite in our briefs. Now, there is a conflict with the 2nd DCA in the Brito case and the Weston case. There's been certified conflict, the 4th DCA certified conflict with TO out of the 3rd DCA. The 2nd DCA in Brito certified conflict with Qureshi. And most recently, the 6th DCA has certified conflict with Qureshi and Rodriguez. And Rodriguez was an appeal I was involved with, and we are waiting to see if the Florida Supreme Court will accept jurisdiction on that certified conflict. But at the end of the day, this court does not have those holdings that the 2nd DCA and the 6th DCA have. This court has Slayton, and the fundamental principle is always going to be the plain language. So there's nothing in this case that would prompt the court to ignore the plain language or delete provisions from the policy or from a statute. It's important to note that the second DCA and sixth DCA were looking at insurance claims that were wholly denied. There was a complete denial of coverage in the Rodriguez case from the sixth DCA. There was a complete denial of coverage in the Brito case from the second DCA. And the Weston case from the second DCA was relying on Brito. So it was applying a very similar analysis to a full denial of coverage, just like Brito. It was basically building on Brito and following Brito. Now, the third DCA is interesting because it has the TO case, which was a full denial of coverage, and they're going to ignore the contract and the statute. But the Vasquez case is the other side of that coin from the same court, the third DCA. And what the Vasquez court concluded is that when we have a claim where a coverage was accepted, like our claim here, we're going to enforce the language. It's in the statute for a reason, it's in the contract for a reason, and it has to be enforced. So that's really the holding that this court should reach in this particular case. The trial court erred by denying our motion for directed verdict on replacement cost value and also on actual cash value because it was not proven, as I previously discussed. Again, nothing that has been argued today or in the briefs would change that. And Your Honors, for those reasons, we would request reversal and for entry of directed verdict in our favor. Alternatively, on the actual cash value, at the very minimum, even if the court concludes it wasn't preserved at trial, it was in the post-trial motions as manifest weight of the evidence. Thank you, Your Honors.
Thank you, counsel, for your arguments and your briefing, and we will stand adjourned. Have a good day.